So on May 14th, 2025, Governor Greg Abbott signed the Texas Senate Bill 29 into law. This legislation introduces notable amendments to the Texas Business Organizations Code, the TBOC, and is part of a broader strategy to encourage more businesses to incorporate or reincorporate into Texas. So I wanted to post on it because it's gonna be important, especially for anyone that's considering Texas or Delaware or Nevada. What exactly did SB 29 do? So I mean, the SB 29 seeks to provide clarity and predictability to companies doing business under the TBOC. Among its key provisions are the codification of important corporate doctrines, such as the business judgment rule and the creation of a kind of novel mechanism allowing companies to have their directors' independence determined in advance of a transaction. And so the law is effective immediately and is expected to influence how public companies incorporated in Texas manage corporate transactions and fiduciary duties, although some of these are very relevant to private companies as well. So, complementing this legislative initiative, though, is that Texas also launched a new Texas Business Court on September 1st of last year. These specialized courts staffed by judges with expertise in complex commercial matters represent a significant step toward hopefully building a robust business law infrastructure in the state that potentially could compete with Delaware. So while Texas business Texas's business courts are still in the early stages of developing their own body of precedent under the TBOC, they do offer an opportunity for litigants to help shape emerging interpretations of Texas corporate law. So you're probably asking, why is this happening right now? And this initiative comes at a time where we have seen, it comes at a time when corporate governance trends are evolving across the United States. Notably, recent high profile decisions from the Delaware Court of Chancery have stirred debate around the role of judicial oversight, uh, in corporate transactions. The Delaware General Assembly, in response, though, to these high-profile cases, enacted their own statutory amendments that offer, management-friendly safe harbors for transactions involving interested directors, officers, or controlling stockholders, so long as certain cleansing mechanisms are met. These changes aim to provide greater legal certainty to Delaware corporations. But in response to Delaware amending their own, Texas decided to amend their Texas business law statutes, and also decided to create the Texas Business Court, which they did, of course, before these amendments and before Delaware's amendment was official or effective. But I think SB 29 and Texas Business Court creation reflect Texas's broader initiative to offer a compelling legal environment for businesses, one that hopes to, I think, emphasize front end clarity while contributing to, the dialogue on corporate governance frameworks and judicial review of corporate transactions. So, what specifically did SB 29 uh, do? Well, the first thing it did was codified the business judgment rule. So SB 29 formally codifies the business judgment rule in Texas, providing corporate directors with a safe harbor from personal liability for business decisions that are made in one made in good faith, two on an informed basis, three in furtherance of the interests of the corporation, and four in obedience to the law and the corporation's governing documents. Right, the certificate of formation is what we call it in Texas, the bylaws and other agreements. Um, it also creates a presumption that governing directors and officers have acted in accordance with those requirements, meaning that plaintiffs have the burden to prove their claims for breach of fiduciary duty in any derivative litigation. This presumption applies only to a corporation that has a class or series of voting shares listed on national exchange, or B included included a statement in its governing documents, affirmatively electing to be governed by this provision. It's also important to note that this law enacts similar provisions for LLCs and limited partnerships. While Delaware does recognize a business judgment rule, its version is primarily a creature of common law, not statute, and potentially may be easier to modify through case-by-case development as a result. Texas was by common law, now it's by statute. Of course, you can elect to be, it's an election though. The second thing SB 29 did was it put limitations on derivative actions. So it permits now, the TBOC permits is the establishment of a minimum ownership threshold for derivative lawsuits. It's for publicly listed corporations or those that have opted in and have 500 or more shareholders to set. And so if you're one of those, you can set a minimum ownership percentage, not more than 3% of outstanding shares, required for a shareholder to bring a derivative lawsuit. This threshold requirement is not automatic. However, it must be identified in the corporation certificate of formation or bylaws at the time the derivative suit is initiated. So by contrast, Delaware law does not impose any sort of ownership thresholds in relation to who may initiate derivative proceeding. The other thing it did, which is interesting, is the attorney fee awards. So it restricts the new SB 29, the new TBOC restricts recovery of attorneys' fees in disclosure-only settlements. So it prohibits the recovery of attorney fees when the resolution of the dispute results solely in a corporation's simply providing additional or amended disclosures to shareholders. This provision, which aims to deter non-substantive derivative lawsuits, means that a plaintiff's attorney cannot recover fees even if successful in obtaining supplemental or amended disclosures. And this change is in line with the shift in Delaware common law, where courts have increasingly viewed disclosure-based settlements with skepticism, given their minimal benefit to corporate shareholders. So, and you can see, I think the case was in Ray Trulia in stockholder litigation. I think it was a 2016 case in Delaware. Another thing that SB 29 did was it created it implemented a novel mechanism for courts to determine director independence early on in disputes. This one's kind of cool. A corporate board's designation of an independent special committee to handle sensitive or significant transactions, including conflicted transactions and internal matters, and whether those committee members were actually impartial, is often at issue in derivative litigation. So unlike Delaware, where courts typically assess director independence during litigation as part of the demand futility analysis or in evaluating the fairness of the transaction that has already been approved, SB 29 allows corporations to ask the court, either the Texas Business Court or the district court in the county of the corporation's principal place of business, to assess the special committee's members' independence and disinterestedness prior to a proposed transaction and before the issue is raised in any subsequent derivative suit. So I mean, to me that's pretty cool. And so I mean, what else do we have? Jury trial waivers and exclusive forum selection. The new SB 29 permits companies to establish exclusive venue in Texas. The new law allows corporations to specify in their governing documents whether the Texas Business Court and or another Texas court will serve as the exclusive venue for resolving any disputes, resulting in mandatory application of Texas's favorable business code provisions. This is similar to Delaware law, but not identical. And Delaware law allows Delaware corporations to include favorable forum selection clauses in their charters and bylaws as well. So it makes sense that Texas would have this in SB 29. Another thing is that SB 29 authorizes companies' elimination of the right to a jury trial. And this actually extends to corporations as well as LLCs and LPs. The ability to include a waiver of the right to a jury trial in their governing documents. Under the statute, such waivers are deemed informed and enforceable against 1, shareholders who affirmatively vote in favor of the waiver, and 2, shareholders who retain their equity after adoption of the waiver provision. So this reform I think attempts to align Texas more closely with proceedings in the Delaware Court of Chancery, where jury trials are unavailable absent a referral of factual issues to the Superior Court. However, Texas presents a constitutional wrinkle, I think, where because the Texas Constitution expressly guarantees a right to a jury trial in civil cases, declaring it shall remain, invalid. While the Texas Supreme Court has upheld contractual waivers of the jury right when made knowingly and voluntarily. It was a 2004 case, um, a Prudential insurance company, I believe, of America. It hasn't, but so Texas Supreme Court has upheld contractual waivers of the jury right in that case, but it has not addressed whether a waiver implemented through shareholder voting satisfies that standard yet. So SB 29 potentially tees up a state constitutional question, whether a shareholder's affirmative vote or continued ownership following adoption actually constitutes a knowing and voluntary waiver of kind of a fundamental right under Texas law. And this is one of my favorite things that was changed. Yeah, again, spectrum based. SB 29 restricts the scope of permissible books and records requests. So it extends the state's restriction on the ability of shareholders to access corporate books and records, because Texas already was a little bit harder, not that much harder though, than Delaware. But in addition to the prior limitation of such access to shareholders who have held shares for a minimum of 6 months, or B, hold at least 5% of a corporation's issued and outstanding shares, SB 29 goes further by exempting email communications, text messages, similar electronic communications, and information from social media accounts, from shareholder books and records requests, meaning that with limited exception where those communications actually, effectuate an action by the corporation, shareholder inspection rights are likely to be limited to more formal documents and communications when subject to discovery. This provision is actually more stringent than the one in Delaware's amendments. So Senate Bill 21, Delaware's was, I think, which permits discovery of email and text messages and similar informal communications when the formal materials are otherwise unavailable and the shareholder can demonstrate a compelling need for the information. In addition, SB 29 also permits public corporations and those corporations who elect to be governed by the codified business judgment rule to limit books and records requests during an active or pending derivative proceeding against a corporation by the requesting shareholder, or a proceeding where the corporation or one or more of its affiliates and the shareholders are expected to be named as adversarial parties. And I think one interesting thing about Texas is that, since you've restricted it and you've made since SB 29 has restricted books and records requests, books and records demands, books and records requests, you might have to look for alternative mechanisms as a shareholder, especially when you're going to, and it's anticipatory of a suit, especially. You might have to look for an alternative mechanism. And I think here maybe Rule 202 of Texas Civil Procedure could be an interesting avenue. But I'll cover that in another video, especially because there's a circuit split on whether you can get document production in Rule 202, which is really about pre-suit depositions. So, and then in conclusion, I just wanted to say that Texas's new law is an effort to create predictable and a business-friendly environment in Texas by hopefully attempting to limit the costs associated with the defense of kind of frivolous derivative suits, and hopefully by protecting the good faith business decisions of company directors and officers. And I think the issue we have here is, given the relatively limited body of case law on which the new Texas Business Court currently has to rely on, it will be interesting to see how the first series of decisions applying these new provisions will kind of set the playing field for Texas businesses going forward.